Good evening. Welcome back to The Particulars. Everything you're about to hear was fact-checked and verified as of about 8:30 tonight. Our cutoff of 5:30 never seems to be, but it is what it is. We're investigators teaching from the public record, our opinion, our analysis, not legal advice. Tonight, the defense rested, but the evidence is not finished. The Commonwealth began its rebuttal with Dr. Avram Mack, and when court recessed, Reddington was still cross-examining him. Judge Sullivan told the jurors to return Monday so testimony can continue. Tonight, we are going to tell you exactly what changed when the defense closed its case, what Mack said in response to Resnick, and what the current model jury instructions say about the legal questions waiting at the end of this trial. Not what people online think the instructions say. The actual Massachusetts framework Sullivan said he is using to prepare his draft charge.
We also have Carmelo Anthony, a murder conviction from June, the original judge's recusal this week, and a motion for new trial hearing that remains unresolved. And we have Flock. After months of pressure and documented misuse, the company announced new defaults and mandatory safeguards. We have covered this arc since episode 1. That is all in the particulars. Let's get into it. A little quick housekeeping. Follow us here on TikTok and subscribe on YouTube so you never miss the replay. Coffee and Sticker Mule are in our link tree. A breaking Davis update on the Keefe D trial. The jury has now heard roughly 2 hours of Davis's 2008 recorded interview. In it, Davis described looking for Tupac after Orlando Anderson was beaten at the MGM Grand, acknowledged that he was prepared to shoot if Tupac had been on his side of the car, and said the gun ultimately went to Anderson. The defense says Davis was embellishing and not even in Las Vegas that night. We will break down the recording Monday.
Backstory for those who may somehow possibly not know about this case. On January 24th of 2023 in Duxbury, Massachusetts, 3 children, 5-year-old Cora, 3-year-old Dawson, and 8-month-old Cal and Clancy, were killed inside their home. Their mother, Lindsay Clancy, a labor and delivery nurse, was found beneath a second-story window with life-threatening injuries. She survived and is paralyzed from the sternum down.
Clancy is charged with 3 counts of murder and has pleaded not guilty. The defense does not dispute that she killed her children. The contested question is criminal responsibility. The defense argues she was suffering from severe postpartum psychosis and was not legally responsible for her actions. The Commonwealth says she acted intentionally.
Before we go further, a content note. Today's testimony includes detailed clinical discussion of suicide, filicide, and postpartum mental illness. If you or someone you know is struggling, the 988 Suicide and Crisis Lifeline is available by call or text 24 hours a day.
Day 17, Thursday, August 20th. A short day with big consequences. Thursday was a short day, 1 witness. But what happened after the jury went home matters as much as anything happened in front of them.
Before testimony started, the docket confirms this. Sullivan conducted a voir dire of all 18 jurors. The judge asked each juror individually whether they could remain impartial. All 18 said yes. All 18 remained seated. Also docketed Thursday, Reddington's motion to add witnesses to the defense list was denied. Decision in order number 184. The defense was going into its final day with what it had.
Chaplain Sheila Cavanaugh, spelled Cavanaugh, defense witness number 9. The one witness Thursday was Chaplain Sheila Cavanaugh, board-certified chaplain at Brigham and Women's Hospital in Boston. She first visited Lindsay on January 25th, 2023, the day after. Lindsay was intubated and could not speak. Cavanaugh returned January 26th and then January 31st. Lindsay had been extubated and could communicate for the first time.
The first thing Lindsay said to her on January 31st was, quote, "I am so glad my children are safe," end quote. Cavanaugh responded that her children were safe. They were safe in heaven with God. And then Lindsay alluded to having heard a voice. According to Cavanaugh, Lindsay told her the voice was male, it was persistent, and it told her that if she did not follow the command, neither she nor her children would be safe.
Cavanaugh testified that the voice conversation came up across multiple visits. She saw Lindsay a minimum of 14 times at Brigham, continued at Spaulding Rehabilitation Hospital, and approximately 200 times at Tewksbury. The voice conversation came up more than once.
And the timing matters. January 31st is before Reddington had any meaningful access to Lindsay, before Zeisel evaluated her. This is not a forensic psychiatrist hired by the defense. This is a hospital chaplain. That is the defense's point in calling her.
Now, Sprague's cross, the notes. Sprague's cross was focused and effective on one point. Cavanaugh wrote detailed notes of every visit. Sprague read specific entries into the record. February 6th, February 9th, February 13th, February 16th, specific quotes. Lindsay's fears about not being able to walk again. Her feeling that she was deserving of this. Her hopefulness about Spaulding. Now, Sprague asked, quote, "You never once wrote that she told you she heard a voice or what that voice said, correct?" End quote. And Cavanaugh's answer, correct.
Now, on redirect, Reddington drew out the chaplain-patient confidentiality distinction. She's not a clinician. She's there to bear witness. Sprague came back on recross. There are direct quotes from Lindsay in those notes. The February 6th entry has specific language in quotation marks. So it's not that the notes are never verbatim. It's that the voice conversations weren't there. Chaplain notes admitted as Exhibit 286. After the jury was excused on Thursday, Sullivan held a preliminary charge conference. The framework. Sullivan said he will use the SJC March 2026 model jury instructions, the most current version from the Supreme Judicial Court. We have that document. We read it. We walked through what it actually says in evidence of the night.
Here is what each side wants. The Commonwealth, murder one on both deliberate premeditation and extreme atrocity and cruelty. Murder two, criminal responsibility instruction, but no intoxication paragraph, and no involuntary manslaughter. Their position is that the evidence does not support intoxication in the legal sense.
Reddington's position, give the jury the intoxication instruction, framed as involuntary intoxication from prescribed medications, side effects, overprescription, and sudden cessation. He also wants involuntary manslaughter as a lesser included offense. His exact words on the record, quote, "I don't know if the government has been listening to the same evidence in this case," end quote.
Sullivan said he will distribute a draft charge to both sides before closings. They will get a chance to formally object. No rulings yet. The jury never hears about this fight. They just receive the instructions on Tuesday.
Potentially
On Tuesday.
So Friday, August 21st, which is day 18, the defense rests.
Today closed the defense case, not the evidence. Dr. Philip Resnick testified as the final defense witness. The defense rested. The Commonwealth then opened rebuttal with Dr. Avram Mack, and Mack was still under cross-examination when Judge Sullivan recessed court until Monday. The docket also shows a renewed required finding motion filed and denied today.
So today, the first witness, Dr. Philip Resnick, defense witness number 10, is actually a final defense witness. He is a forensic psychiatrist based in Cleveland, Ohio. He testified via Zoom today. He was discharged from the hospital Tuesday and was advised not to fly. His case history includes the Jeffrey Dahmer prosecution, the Unabomber case with the government, Casey Anthony as a defense consultant, Andrea Yates for the defense, the Aurora movie theater shooting as a state witness, and the Oklahoma City bombing with the government. So all of this to say that he does work for both sides. That list was not an accident.
He evaluated Lindsay in person for 3 hours in May of 2023, 4 months after the crime. The government's 3 experts evaluated her approximately 3 years after. That gap came up on direct. Resnick's diagnosis: bipolar 2 with a severe depression. On January 24th, 2023, Lindsay Clancy was frankly psychotic. She met 7 of the 9 DSM-5-TR criteria for major depression as she approached the date of the crime. He testified that she was functioning until she had a command hallucination while Patrick was out.
He explained command hallucinations in detail. A hallucination is simply hearing a voice, benign or malignant. About 1/3 of voices are command hallucinations and instructed to do something. The majority of those commands are benign. The dangerous ones instruct harm to yourself or someone else. His opinion: Lindsay had not just a command hallucination, she also had a delusion of influence. So she felt her body was taken over by an external force. She felt she was obeying, not deciding.
Now, on the 2 prongs of criminal responsibility, can you appreciate the wrongfulness of your conduct, and can you conform your conduct to the requirements of the law? Resnick's opinion: due to her mental disease, she was unable to conform her conduct to the requirements of the law on January 24th.
So, the 5 categories. Resnick has categorized filicide, the killing of one's own child, into 5 types. So you have altruistic filicide, committed out of love, a belief the killing is best for the child. You have acutely psychotic filicide, where a frankly psychotic person acts on distorted thinking. Then you also have child maltreatment filicide, abusive deaths, unwanted child filicide, where the child is seen as a burden, and spouse revenge filicide. So his opinion, only the first 2 apply to Lindsay Clancy.
Now, on Sprague's cross, it went directly at Resnick's own published work. She introduced a training he gives and used his own language about not volunteering information beyond a question. He disputed the characterization. She also pressed the filicide's statistics from his own articles. Most women who kill their children do not do it because of mental illness. The most common motive is fatal maltreatment, child abuse. He agreed with both positions from his own research.
Then the Andrea Yates comparison. Yates committed herself 5 times, tried to kill herself twice, and did not kill her children during any of those episodes. Sprague asked, until she could no longer, right? Resnick's answer: yes, until she could no longer, as did Miss Clancy.
The moment that got struck, Sprague asked, and I am reading this carefully, quote, "So it's better to kill them than to have them taken away," end quote. Sullivan struck the question immediately. The answer was stricken. The jury was instructed to disregard.
So redirect, 2 words. No thank you, doctor. Reddington sat down, and then the defense rested.
Now the Commonwealth rebuttal. Dr. Avram Mack. After Reddington rested, the Commonwealth called its rebuttal witness. The first, Dr. Avram Mack, a psychiatrist with 22 years of experience. He evaluated Lindsay in April of 2026, April 10th and April 12th. His diagnosis: major depressive episode, likely part of major depressive disorder, not bipolar, not psychosis.
His key point on bipolar: you cannot diagnose bipolar disorder without a documented episode of mania or hypomania. He testified there was no evidence of any manic or hypomanic episode in the records. That is a direct conflict with Resnick's bipolar 2 diagnosis. So you have 2 forensic psychiatrists, same medical history observed, different diagnoses.
Now on psychosis, Mack testified that he found no evidence Clancy was psychotic. He emphasized that the DSM-5-TR used a, quote, with peripartum onset, end quote. Specifier, when symptoms began during pregnancy or within 4 weeks after delivery. That is the DSM classification language he relied upon. It is not the same thing as saying every postpartum mental health condition medically ends after 4 weeks.
Through Dr. Mack's direct, a specific detail came in. Lindsay told him that while she was taking the lives of her children, she was saying, quote, "Go to God," end quote. That is sourced to Dr. Mack's testimony, Lindsay's statement as reported to him during his April 2026 evaluation. That is how it is attributed.
Mack also noted 2 discrepancies between Lindsay's account to him and other evidence. She told him she cut the window screen before going through it. Whether that screen was actually cut is a question in the record. She also denied closing or locking the bedroom door. Patrick's account and case reporting suggest the door was closed or locked. Mack flagged both as inconsistencies.
So the Mass Court's docket shows that Reddington filed a renewed motion for a required finding today, and Sullivan denied it, because the Commonwealth's rebuttal is still underway. We are not going to call that the close of all evidence. Court resumes Monday with Mack's cross-examination and the remainder of the rebuttal case. Sullivan said the final charge conference will follow at some point. He did not promise the jury that closings begin on Monday. We are going to move on to our next segment, which is evidence of the night. And this is, again, technically continuing on with the Commonwealth versus Lindsay Clancy, what the jury will be told. So tonight's evidence of the night is a document. It's actually the Massachusetts Supreme Judicial Court's March 2026 model jury instructions on homicide. Sullivan said he is using the current model instructions to prepare a draft charge. The final instructions have not been issued, so this is the governing framework and the subjects being disputed, not a claim that we already know every paragraph the jury will receive.
Start with criminal responsibility. The Commonwealth has the burden. They must prove beyond reasonable doubt that Lindsay Clancy was criminally responsible.
The model instruction says a person is not criminally responsible if, because of a mental disease or defect, the person lacked substantial capacity either to appreciate the criminality of wrongfulness of the conduct or to conform the conduct to the requirements of law. Either form of incapacity can satisfy the defense. So once criminal responsibility is properly raised, the Commonwealth must prove beyond reasonable doubt that the defendant was criminally responsible.
The instruction also tells the jury that, quote, mental disease or defect, end quote, is a legal term, not a medical term. It doesn't have to fit a formal medical diagnosis. The jury decides what qualifies, not the doctors.
The charge conference also previewed the homicide options the parties are litigating. So the Commonwealth requested first-degree murder under deliberate premeditation and extreme atrocity or cruelty, along with second-degree murder. Those requests are not yet the judge's final charge.
Now, deliberate premeditation requires the defendant caused the death, intended to kill, and committed the killing with deliberate premeditation, meaning she decided to kill after a period of reflection. The instruction is specific. No particular length of time is required. A decision to kill may be formed over days, hours, or even a few seconds. What matters is the sequence: consideration, decision, act.
Extreme atrocity or cruelty is the second theory. The jury considers 3 factors: whether the defendant was indifferent to or took pleasure in the suffering, whether the method was reasonably likely to substantially increase or prolong conscious suffering, and whether the means used were excessive and out of proportion to what would be needed to cause death. The jury must find at least one of those factors.
And then the open dispute from Thursday. Does the jury get the intoxication instruction? Does it get involuntary manslaughter? No ruling yet. Sullivan distributes a draft. The jury never hears about the argument.
So here's what I keep coming back to analytically. The criminal responsibility instruction is not, is she mentally ill? The question is much more specific. Did the mental disease or defect cause her to lack the substantial capacity to appreciate the wrongfulness of her conduct, or to confirm her conduct to the law. That's a different question than whether she was depressed. You can be severely depressed and still be legally responsible. The jury has to find that the defense drove the incapacity, not just the disease existed. And I feel like where we are today, we still are having a disconnect.
We are going to be moving on to our next segment.
Legal Minute. That's slated to be 6 to 8 minutes. We are in McKinney, Texas, in Collin County in June. Carmelo Anthony was convicted of murder, not first-degree murder, which is not the Texas offense label, and sentenced to 35 years for fatally stabbing 17-year-old Austin Metcalf at a high school track meet in Frisco in April of 2025. Anthony was 17 at the time and is now 19.
This week, two things moved this case in a new direction. First, the original trial judge, Judge John Roach Jr., was recused on Wednesday. Retired Judge Michael Chitty was assigned to hear Anthony's motion for a new trial. Second, that hearing began Thursday and ran through today. Now, the center of the new trial motion, the prosecution and defense agreed before trial to withhold certain evidence. Their stated reason: the case was already inflamed by racial tensions and death threats, and they mutually decided to keep specific material out to prevent further escalation. That agreement is now at the heart of whether a new trial gets granted.
So, what was withheld? Among the material disclosed at this week's hearing, text messages Anthony sent his girlfriend in the period before the stabbing. Prosecutors described messages discussing stabbing someone and, quote, licking the blood off the blade, end quote. A message saying, quote, I'm low-key on the verge, end quote, hours before the attack. The defense's position is that the agreed-upon withholding, along with other alleged trial errors, warrants a new trial.
Now, let's define something. A motion for new trial is a post-conviction request asking a judge to set aside a verdict and order the case retried. The burden is on the defendant to show that errors at the original trial were sufficiently prejudiced to warrant starting over. It's a high bar. If granted, the conviction is vacated and the case goes back to trial. If denied, the next step is typically an appeal.
So as of tonight's production cutoff, the hearing is still running, which I don't know if that's the case, obviously, because it's 10:30, but we cut off 5:30. Judge Chitty has not issued a ruling. We do not know when the ruling comes. What we can tell you is what is being argued and why it matters legally.
Our read as analysts, the withheld evidence disclosure is the unusual element here. It is not common for both prosecution and defense to agree pre-trial to keep evidence out for de-escalation purposes, and then have that agreement become the center of a new trial. Whether Judge Chitty decides, the fact that this agreement existed is now on the public record.
So moving on to our final segment of the night, which is our red flag. So Flock changed its own rule. We have been covering flock safety since episode 1 of this show, and tonight's episode is episode 21. So, license plate readers. Fourth Amendment questions. Individual officers misusing the system, departments not monitoring their own people, Newport, Kentucky pulling their cameras, the Laramie County arrest. Tonight is the next chapter.
On August 13th, Flock announced several changes. It changed its recommended or default automated license plate reader retention period from 30 days to 7 and introduced an evidence mode for preserving selected data in active investigations. But existing customers keep their currently approved retention periods unless they chose to change them. By the end of 2026, Flock says law enforcement customers must adopt audit assistance and use case codes for searches, subject to an emergency exception that will be flagged for review. Flock also announced proactive lockouts for abnormal activity.
Flock CEO described the August 13 changes as moving some previously optional safeguards toward requirements. The 7-day period is a recommendation and default, not a virtual forced change for every existing agency. The mandatory pieces announced for year-end are audit assistance and case codes, along with new lockout and security measures. And today, August 21st, Flock announced additional contract changes. It says it removed language that allowed Flock itself to disclose customer confidential information to a government agency in an imminent harm situation, leaving that decision with the customer. Expressly prohibited using the service to mislead, harass, stalk, or violate another person's legal rights, and expanded its ability to suspend access when it reasonably suspects misuse. Flock also says the revised online terms do not automatically alter separately negotiated agreements.
Have I Been Flocked? A public records project launched, allowing people to search audit logs obtained through records requests to see whether a plate appeared in a released data, who queried it, and the stated reason. The ACLU has separately promoted a Get the Flock Out campaign.
The red flag is not that Flock announced changes, it is the sequence. So the network reached enormous scale before these oversight tools became mandatory. The announcement itself says only about 1/3 of customers had voluntarily adopted audit assistance before Flock decided to require it. The new rules respond to demonstrated misuse and public pressure. They do not erase what occurred under the earlier system.
And here's the media literacy takeaway on Flock. When a technology company announces new safety controls under public pressure, the question worth asking is not just what changed, but what was in place before. Optional guardrails that weren't being used are not guardrails. They are features. The difference between a feature and a requirement is what accountability actually looks like. That's where the particulars stand tonight. If this is your first time here, we teach from the public record. We tell you what's confirmed and what isn't. And we never pretend a headline is a fact.
Court resumes Monday with Commonwealth rebuttal still underway. Mack's cross-examination is not finished, and Sullivan said the final charge conference will happen later. We are not going to guess when closings begin or when the jury gets the case. We will follow the evidence through the actual close and then walk the final charge when Sullivan issues it. Follow us on TikTok and subscribe on YouTube so you never miss an episode. Coffee and Sticker Mule are in the link tree. And because tonight's episode included testimony about suicide, self-harm, mental illness, and the deaths of children, we want to leave this here. The 988 Suicide and Crisis Lifeline is available by call or text anytime. This has been our opinion,
Our analysis.
not legal advice. Headlines end.
Details begin.
We'll see you Monday night at 9:00 p.m. Eastern for
Episode 22.
The Particulars.
22. That's it for tonight, guys. Thank you all so much. Thank you for the support. We appreciate it. We'll see you on Monday.
Have a good night, guys. Have a great weekend.